This is a reminder. Take Karen's meds.
All right, good morning. We're here on the Family Law Docket B for February 9th. I'm Commissioner Dave Nelson. Thank you for being here. Let's first take the case of White and White.
And I'm here on that matter as well, Your Honor.
All right.
Representing Mr. White.
You represent Mr. White. Ms. White's motion to reestablish visitation. Mr. White requested a week to respond last week, so I put it over a week. So I think what I want to do is hear from Ms. White first, and then we'll go to Mr. South and Mr. White to respond. I did see the declaration that was put in by Mr. White. So Ms. White, do you want to go ahead and address your motion? Ms. White, can you hear me okay?
Yeah, can you hear me?
Now I can. There we go. Now I think we're
Okay.
synced up. Go ahead.
Sorry about that. So I submitted basically all the proof that he is saying that I didn't do anything of. Like, I submitted proof that I completed outpatient drug treatment, that I did the hair follicle test. I've done so many UAs, obviously, in my time at treatment, and since. Like, I don't have a problem with doing another hair follicle test or any drug test at that matter. Honestly, though, like, he needs to start paying for it because I've put so much money out for this. It's adding up, Your Honor. It is. And this case is just getting drawn out and drawn out for no reason. Like, he was supposed to set my daughter up with counseling. Actually, he was supposed to set them both up with counseling. Because how am I supposed to set a child up with counseling that I don't even have? It makes no sense. So he was supposed to set up the counseling. Since then, I've set up Sydney with counseling. She's going regularly. That's not a problem. I just, when the child's not in my care, I can't really do much. So he should have done that long ago. I've been wanting my daughter I've been wanting them both in therapy for a long time. But it hasn't happened. So I really just want to get my visitations reestablished so that I can start seeing my daughter. Like, it's detrimental to her emotional and mental health, that this is happening. This is still happening. It's going on for so long. It's not necessary.
So there's two daughters, right? Sydney and Savannah.
Correct.
And Sydney lives with you most of the time right now?
All the time, yes. He has not seen her since she came, or even spoken to her since she moved in with me. He kicked her out.
Okay. So Mr. White's the father, though, of Sydney?
Correct.
Okay. I was wondering if there was a visitation plan with Sydney, and it sounds like there is not at this point.
No, Your Honor.
Okay. All right. Let me hear from Mr. South, and then you'll have a chance to reply to what he says.
Yes, Your Honor. Just to kind of clear things up, Sydney is 17 years old, and she was having some real behavior problems that were affecting both Savannah and Mr. White's other children. And that's why she's with mom. But the court, the last time Ms. White attempted to reestablish these visitations, the court was real clear on what she needed to do. And you've read the declaration. And
Sweet Jesus.
Sweet
Jesus.
And that's the order that's from August 16 of 2021.
Correct.
Which I have in front of me. So
yeah, and we've included the pertinent language in the declaration. So we suggest that she hasn't done what she needs to do. She did provide a certificate that she completed outpatient, but we don't really know what that is. She needs to give some more documentation. She was supposed to provide documentation throughout her treatment, which she hasn't done. And again, that was completed, I think, in April of last year, and doesn't really show what she's been doing since. As far as the hair test, she's provided no proof that she's taken the hair test. She did provide a receipt. She didn't provide results, which again is kind of interesting. If you took a hair test and it was clean, you would want the court to see that. You wouldn't not provide it. And plus, again, that was done in March of last year, so it's almost a year old. So it certainly isn't current. It certainly doesn't provide the court information whether she's clean or not. And then also the reunification counseling has not taken place. I remember back when this happened, Mr. White was looking hard to try to find somebody who would do some kind of reunification counseling, and he just couldn't find anyone. And I guess that just kind of maybe went by the wayside. But the petitioner matter has just not completed what was required of her to do this counseling. At the very least, she has to do a clean hair follicle test, and then we can look at doing some of the reunification treatment or counseling. Thank you.
All right, thank you. Ms. White, any response?
Yes, Your Honor. When I went and did the hair follicle test, I did it across the street from Safeway on 15th. And I don't know why, but when I went in there, I did the hair follicle test and I asked them about the results. They told me that they wouldn't submit them to me. So I signed a release, and you should have documentation of that too, that the results got sent to Mr. South. So Mr. South should have them. I don't know why they wouldn't release them to me, but I signed a release of information so that he could get them.
All right,
So,
thank you.
Yeah.
So I think we need to go back to the court's previous order, which was in August 16th of 2021. And the same motion was brought at that time, which was to reestablish visitation. And the court made three requirements. Number one was that Ms. White provide written documentation of any compliance with treatment, including drug testing done. It must be filed with the court and the respondent's attorney. Number two, submit and provide to the court and respondent's attorney a copy of a recent drug test done by way of hair follicle testing, and that would be done at Ms. White's expense. And then three, attend reunification counseling with the children. It would involve the children first, and once the counselor is satisfied it is best for the children, the petitioner shall attend, and indicates that counseling shall be scheduled within 14 days, which it wasn't. So what do we do today? I think we need to follow at least the framework of that order and get some updated information. At this point, I'm not sure how helpful documentation of compliance with treatment that happened 2 years ago is going to be, but certainly a hair follicle test done in the next week and provided to the court and to Mr. South is something that would be very helpful. And determining how to go about reunification counseling would be helpful. And at this point, we're just talking about Savannah. So it's apparently Sydney is living with the mother at this point. So here's what I'd like to do. I'd like you to do a hair follicle test between now and let's say next Monday. I don't know how early you can get it in. I'd like it to be as soon as possible, but I think it may be a little bit short to do it between now and tomorrow. Between now and next Monday, I'd like that provided to Mr. South and filed with the court under seal. And then I would like to be back here actually in 2 weeks. So we have a chance to evaluate that. I think that's February 23rd. So let's come back here on February 23rd.
Your Honor, can we do that 3 weeks? This is the Thursday Wahkiakum docket, which I'm late for, but they're every other week. If we could get this on a schedule where I'm not supposed to be in Wahkiakum.
Can we do it next week then? I'd like to kind of move this along a little bit more.
I'm not sure.
I'll go.
That's fine. If we
Your
can get the
Honor,
results.
I will go in there today.
Okay. Let's go next week then. I assume next week is not your Wahkiakum docket, Mr.
No,
South?
but unfortunately, I have a mandatory settlement conference at 9:00 next Thursday.
Okay. Well, I guess we'll have to go 3 weeks. So is that March 2nd? I'm sorry,
Yes.
calendar with me. Assuming the hair follicle test is negative, then we'll talk about how we'll approach reunification counseling with Savannah and try to get that going so that we can continue to follow this order. And I think the goal of this order, the goal of this court is that eventually you're able to see Savannah and be able to have fairly normal visitations. We need to take these steps in order to ensure that she's safe and that this is done appropriately. Okay. So we'll see everybody back here on March 2nd. And if you can do the test right away, that would be great. Okay.
Yes, Your Honor. I have a question really quick.
Go ahead.
Our parenting plan, it says can ask either one, each other to submit, like a drug test. And I was just wondering if I could request that he do a drug test as well.
If the parenting plan calls for that, I'm not sure what it says in terms of who pays for what, but if it allows for that, what I would do is make a written request to Mr. South that Mr. White do a drug test and indicate what test that you'd like him to do.
Yes, and I believe the parenting plan says the requesting party has to pay for that.
Okay, so when I was notified that I had to do the drug test, I wasn't notified in the morning of. I was just called and told, hey, you need to do a UA. But there's been some serious allegations of him like trying new drugs lately, and I've just caught wind of this, and it's really concerning to me, Your Honor.
Okay.
So I would like him to do a test too, if that's possible.
Okay, and I think as Mr. South indicated, to do a UA requires that you initially pay for it. If it's negative, then you'll end up paying for it. If it's positive, then Mr. White will pay for it. That's apparently in the language of the parenting plan. So
yeah, Your Honor, I've paid for mine. I'll go pay for his right now. Not a problem.
All hers were negative. All hers were positive. That's why she paid for them.
Okay, well, I think under the parenting plan, it sounds like she can ask for it. So if you want to prepay for that, let Mr. South know, and Mr. White will go in and do a UA. Okay?
Wonderful. Thank you.
And we'll look at
Mr.
those tests
South?
then on March 2nd.
He needs to do a UA, Mr. South.
Okay. Thank you.
Thank you, Your Honor.
Thank you.
Your Honor.
It's Lettos and Christine Lettos.
I think I'm here. Is my voice working?
Yes, your voice is working.
Awesome.
I'm here.
All right, it's Melissa Hiltz, is that right now?
Yes, sir.
All right, Miss Hiltz. And I know Mr. Lawrence is here on that case. So we're hearing a number of things. One is a motion for adequate cause. Another one is Ms. Hiltz intends to move, I believe, to Pennsylvania. And the third issue is a request for a contempt motion for failing to use the application Talking Parents. So Ms. Hiltz, I'll let you take the lead and make whatever argument you'd like.
Okay, so on the contempt, I put on there for the contempt for Talking Parents and also for child support. Christine is behind in child support, in daycare, in medical expenses. And when I've reached out to her, she tells me that they take it out of her paycheck, which is true. I do occasionally get partial payments from her paycheck. However, they're not the full amount. And in the past, she has regularly worked for cash under the table. So the fact that she's not paying her child support, but I also believe that she has the ability to do so, puts her in contempt. One of the reasons I believe she has the ability to do so is because she came up with a $1,500 payment to Mr. Lawrence within a very short time frame. And additionally, because she stated 3 weeks ago in court that she goes out to see her family in Maryland, I believe, Baltimore, twice a year for about a week, telling me that she has the funds for airfare and taking time off work. And then also with Talking Parents, my issues are there that, I mean, it's court ordered in the parenting plan, actually in two separate locations, because I wrote it myself and missed that, but at least under the section at the end on the other, it's very specific that all parties are supposed to, all communication is supposed to go through exclusively through Talking Parents under 14A. And the reality is she hasn't responded to any messages there since 2021, which is making communication really problematic.
When are you planning to move to Pennsylvania?
My hope is around the end of May or the beginning of June. I have not secured housing yet. And so that is still up in the air. Are we hearing, because I'm a little confused about what we're doing today. At first, I thought we were doing the parenting plan, but then when I looked online, it looks like we're not scheduled for that. And after hearing what you said last week about possibly needing to go to trial, I'm wondering if that's where we're headed, and just setting a trial date.
Well, in terms of the move where there's a notice of intent to relocate, that typically is handled through a trial with an evidentiary hearing. What we may do at the end of our time today is put you on the trial setting calendar so that can get set fairly quickly.
Perfect. I think that was going to be one of my requests.
Yeah, I think I did want Mr. Lawrence to get involved right away regarding that relocation.
I understand.
I'll hear from Mr. Lawrence in a minute, but at this point, Ms. Lettos, I'd like to hear your response to both the child support issue and also the failure to use the Talking Parents app.
I don't work under the table anymore thanks to COVID. So I don't have a car to get down to Longview to deal the poker games she's talking about. So I don't have any other income besides the income from Golden Foods. And I'm working as much as I can. They're taking as you know, they're taking as
When you
much as they can
say
from my check.
they're taking, is that the child support
The child
division?
support, yeah, the state's taking it.
Okay.
And I'm working more hours because I haven't had a day off since Christmas. So I'm getting more paid out. I was unable to appear at that final court hearing because my electronics didn't work. And I showed up at the courthouse and was unable to be seen. But I've tried to use the Talking Parents. And I've been online once, and then when I go online, there's nothing there. But Melissa has proven that she can get a hold of me as she needs. And the fact that I was aware of these trial dates.
Well, but you've used other
she also
social media
refuses-
to talk to each other,
Right.
which is not what's required.
I understand. She also refuses to serve me at the physical address of 200, which is the physical address I want to be served at, and she refuses to serve me.
Your Honor, regarding that address, that's a hotel. And then that same address also is a parking lot for long-term parking for SeaTac Airport.
It is also Golden Foods.
Let's not talk at the same time. Let me hear from Ms. Hiltz first.
I'd be happy to serve her at that address if she'd give me either a room number or a space number. But a hotel and a parking lot for long-term parking is too large of a location for a server to figure out where she is.
Your Honor,
Yeah, go ahead, Ms. Lee.
this is my employer. Anybody there will have no problem finding me.
Well, a process server a lot of times would have to give the papers to you directly. Would they be able to locate you directly?
Yes, they would be able to locate me.
Let me hear from Mr. Lawrence, and then we'll make some decisions. But actually, before that, Ms. Hiltz, what amount of child support are you claiming is owing at this point?
Well, what it is, I went into the state's database. It's in the contempt. And she's behind by $3,135 for Glenn and $3,772 for John. It's possible that the money for John, part of that is owed to the state because I was on TANF for a time. So I'm not actually sure when I look in the system, which part of that $3,700 goes to me and which part of it goes to the state. She's also behind on past due medical for $563.49, and past due daycare, childcare is $1,165.94.
Give me that number one more time.
$1,165.94 for childcare.
And that would be half or a proportional amount.
That is her 53.3%.
Okay. All right, Mr. Lawrence.
Yes, Your Honor.
What I read was that there was some issue about payment, and so maybe your investigation hasn't started yet. Is that right?
Well, I contacted Melissa first and indicated to her that this was a private pay situation. She responded that she would be happy to pay her half as soon as the check cleared from Christine. And so I contacted Christine about all of this, and she immediately made a direct payment through Zelle into my bank account. And I set up an interview to speak with her about a week ago. And then I contacted Melissa to let her know that Christine had paid. And then Melissa indicated she didn't have the funds. And so we're kind of at a standstill right now until I can get assured that I'm going to get payment from Ms. Hiltz.
And I think Ms. Hiltz filed a financial declaration that I think showed $1,400 a month is what she got. That would be, I think, below the standard that you would need to be. She would qualify for county pay at that amount. So I'm willing to change the order to have her half paid by the county given that income. So would that resolve that issue for you, Mr. Lawrence?
Yes.
Okay.
Your Honor,
Yes.
regarding the guardian ad litem appointment, considering he hasn't started his investigation yet, and I fully expected this to be completed by today, honestly, I'd like to have a different guardian ad litem. I have really strong concerns about his focus on this case being in the right spot. But I certainly can go into, but don't need to if it's not necessary. Because he hasn't started his investigation yet, is it possible to have a different guardian ad litem appointed?
The short answer to that is I'm not going to do that. I don't change guardian ad litems.
Right, then can I go?
In the time I've been doing this, I've never changed one.
Okay,
If you feel you want to go into the reasons,
I
you
do.
can. The fact that you showed me a Facebook entry, which really did not indicate to me that Ms. Lettos and Mr. Lawrence were Facebook friends. She simply showed up because she knows somebody else that Mr. Lawrence is Facebook friends with. But I've read his initial report. I don't think he was very kind to Ms. Lettos in that report, so I don't question his objectivity based on that. I think having Mr. Lawrence involved is going to save a lot of time and a lot of money, actually, compared to having another GAL involved. But if you want to give me your reasons to convince me that I should pick another GAL, I'm happy to listen.
So if you look at his Facebook right now, he currently has 15 friends. One of those is Chris Lettos. In his original report, he recommended a 4 on 3 off parenting plan, 3 overnights with Christine. She currently has 3 hours a month of professionally supervised visitation due to 191 factors of neglect, of drug and alcohol abuse, and of lack of emotional ties to the children. His report in no way got close to what I felt was the best interest of the children, nor was it close to what the court originally did. And my other concern is that in his statement, he let me know that he believes that his role or his primary job is to make sure that both parents have access to the children. And while I can see that that's important in most cases, in our case, at what point does access to the children by a parent become not in the children's best interest? And as long as we keep the focus on the children's best interest, 100% only what's best for them, then that's who I want. I want somebody who can keep my children's interests in their heart, not Christine's interests in their heart. I'm not quite sure how to show that they are currently friends on Facebook, but other than the screenshot I provided, but it is public information.
Your Honor, may I respond to the Facebook information?
Please go ahead.
Prior to Zoom, I used Facebook Messenger in order to use that as a vehicle to provide video conferencing with clients. That is the only time that I ever use Facebook. I am not a Facebook user. I don't even want to waste my time on that program. But it did provide a vehicle to provide video conferencing, and I used that with Chris, but that was the only time that I've used that.
I want you to know I have written down your concerns. I understand your concerns. Mr. Lawrence obligation is to provide a report that's in the best interest of the children. And I think he understands that. And at this point, I don't see where he should be changed. And I think it will result in a less expensive report if Mr. Lawrence stays involved, because he's already been involved in this case. So I'm not going to change him. All right, let me go to the contempt issue. I don't know what the work situation is, but a party that owes child support is required to pay it. And so what I've got is behind on child support at $3,135 regarding Glenn. There was some question on John as to whether that was paid to the state. So I'm going to reserve on John at this point, but I am going to put past due child support of $3,135. Medical payments, I'm going to accept at $563.49, and daycare will be at $1,165.94. Concern about the failure to use talking parent is there's already been a contempt order relating to that. It continued to not be used. I'm not sure why, and it seems that it would not take a long time to learn how to use it. Clearly, there were a number of attempts at communication from Ms. Hill that were never responded to. So I do find that there was, and there is, contempt for failing to use that program. Starting today, we need to communicate through that program because that's the court's order.
Is there another program we can use? That one is not working for me. There are other talking parent apps that would work.
Well, it's not going to change the contempt ruling.
No, but
today.
I would like to move forward and communicate and have a program that works.
I know there are other ones. Mr. Lawrence, would you have a recommendation?
Our family wizard is used by a lot of folks.
Would you be willing to change to another program, Ms. Hiltz?
I am. The reason I chose Talking Parrots, or that we had actually originally agreed on it, was because it was free. Our Family Wizard, I believe, is $100 or maybe $150 a year for the program. So if Christine wants to go ahead and foot the bill for both of us to switch over to a more expensive app, I am certainly okay with that.
I cannot afford that. I make $1,800 a month.
Your Honor, she just stated she was working every day, and her previous income was shown to be $22 an hour, which I personally know is probably an understatement. $22 an hour at 40 hours a week at 4.33 weeks per year is $3,810 a month.
Your Honor, I don't know where she's coming up with this. I make minimum wage. Please don't roll your eyes.
All right. I'm not going to order that Ms. Lettos pay for both parties on Our Family Wizard if both sides can pay for it and use it, great. Otherwise, we're going to stay with Talking Parents, which apparently is free. And Ms. Lettos, you'll need to, I guess, address how you can get that to work on your device. At this point, I'm going to assess a civil penalty for failing to use talking parents of $500. I'm not there. You did put in your order also attorney fees, but there's no attorneys involved, so I'm striking that portion. I'm also not ordering jail time. So if this comes before me again because of failure to use a parenting app, that would be the third contempt, and that may warrant jail time at that point. All right, I'm going to change the appointment of guardian ad litem so that Ms. Hiltz portion would be paid by the county. And then the final thing I'm going to do is put this on the trial setting calendar at 1 p.m.
Can we move that to a week later? I am going to be at my mother's in Baltimore.
So that would be March 1st.
That works, or even before, but that
Well,
week is.
I would set it the next week, but that docket is full
Okay,
and I can't put anything on it. Would you be, it's going to be on Zoom. Would you be able to call in from your mother's? House?
I'm not sure. I'm sure my brother has the technology to do that.
Miss
but-
Hiltz has something to say. Why don't I hear from her?
My son has an echocardiogram on the 22nd.
Oh,
Um,
okay,
of
so
February.
you'd be okay with March 1st then also?
Yeah,
Okay. So then let's put it on for March 1st at 1 p.m.
thank you.
Mr. Lawrence's report will be relevant at the time of the trial. So I think you'll have plenty of time to put that together. Trista Jones and Bradford Jones. I see Mr. Jones is here. Is Trista Jones?
Yes, I'm right here.
All right. Good morning.
Good morning.
So this is a motion for contempt by Ms. Jones for failure to pay spousal support based on the order that was entered by Judge Hahn. Mr. Bradford Jones, I believe, is saying he wasn't aware of it and has his own concerns. So, Ms. Jones, why don't I have you address the court first, and then I'll go to Mr. Jones.
At first I had it at $500 and he got very upset over that. So I changed it. I told him that I would take it and go and have it modified. He set 3 dates for us to go. He never went. So at this point, I don't want to do that. We were married 28 years. Yes, there was years we weren't together, but he was incarcerated at least 80% of that time. And I don't feel that $200 for 28 years of an awful marriage is too much to ask for. And he has made it very clear to me that he is not paying it.
Okay. Mr. Jones, would you like to respond? You're muted right now, so I need you to unmute if you can.
Yeah, no. Yes. Yes, sir.
All right, I think we can
I'm trying to
hear
get-
you now.
Okay. Can you hear me?
Yes.
Okay. Hi, sir. I was served the papers, sir, actually, and I really didn't think they were real papers or whatever. And
Even though somebody
I
went to the trouble of personally giving them to you?
one of her friends did. Well, she used to be a friend of both of ours, actually.
All right.
And Your Honor, I haven't been with my Trista since 2011, and I've been in and out of incarceration for a long time, actually. And I just recently got out, going on 2 years ago, I had 1 year of DOC, 4 years of federal paper. I'm still currently, I completed my DOC. I'm currently doing, I'm coming up on 2 years of completion of my federal paper. And I'm just not looking for any trouble. All I really wanted was a simple divorce. But I due to my default, she asked for money and she asked for a car. And I'm not understanding, you know, I have medical issues. I have stage 3B kidney disease. I'm about to go on dialysis. I don't work. I gave her the car, and she told me I complied. The commissioner told me to send this paper in that I sent. I think it's in front of you probably for the contempt, and I stated my reasoning. And I just don't understand. You know, I haven't been with her in 13 years, and during our whole 28 years, I think we've only been together maybe 6 years. And that was in the 90s.
I would like to reply to that.
Yeah, you'll get a chance, but let
Okay,
Mr.
thank you.
Jones finish.
Thank you.
I did see your declaration, Mr. Jones. You indicated that if you gave her a certain car, I think it was the Scion, if I remember right, although I may
That is correct.
That she said she would just let everything go, and she's saying that's not true.
Well, I did that. I did that, and I got a letter right here in the mail yesterday from her. Another declaration from her. I don't know if you got a copy of it, whatever, but it is filed through the courts.
That also is filed.
Okay, well, she in the letter that she wrote, she's saying that she did say that at first, but now she's recanting on that, and I don't know. I don't quite understand. I don't understand. I'm applying for disability due to my diabetes and my 3B kidney disease. I don't work, and they're only going to give me $700 and something, and I don't get it. And $200 a month out of $700, that's ridiculous. Like I said, I haven't been with her since April of 2011.
Ms. Jones, any response?
Yeah. First of all, the majority of that time he was locked up, as he said. I have a reputable business owner that was with me when we went to transfer the title. She was there to give me the money to transfer the title myself. He said, no, I'll get it. I'll do it. I never said that if he transferred the title that I would forget all of this. I never said that. I am on disability due to physical, emotional, and mental abuse that I suffered from him all those years. And so now that we're doing the right thing and we're both living the right life, I'm the one that lost out. Now somebody else is getting everything I ever dreamed of and wanted. And he's got that. I personally know of 1 truck, 2 cars in his name. How does he pay his bills? What am I trying to say? He works for himself and he makes very good money. He's been seen at the ATM taking money out. He's been seen at Walmart sending his daughter Amber in Texas money that could have went to me. So, I mean, he doesn't have disability yet. I do. And I suffer a lot and I have a lot of problems going outside, doing everyday normal things.
Has he paid any of the child support since the order was entered?
He has not paid nothing since July 1st is when he was supposed to start.
I don't owe child support, sir.
Oh, not child support.
I misspoke. Spousal support.
He hasn't paid.
He hasn't paid anything.
No.
Okay. All right, Mr. Jones, here's where we're at. You indicated you thought these papers were not real, but they were real. They were served on you You didn't respond to them, and as a result, there was a default entered against you. And I'm going to talk about that in a minute. Based on
Yes,
the
sir.
default, Judge Hahn of this court entered a decree of dissolution that requires that you pay $200 in spousal maintenance. That order was entered in May of 2022, and we're now at past January, but from May to January is 9 months. And at $200 that was owing for each of those months, that would be $800 that's owing. So I'm going to enter an order of contempt saying that you owe that $1,800. Now, what you may consider, sir, is if you don't agree with the order of default, you can bring a motion to set aside the default. That was entered, I think, in April or May of 2022. And you need to bring that motion within a year of that order. So that gives you only a couple months to bring a motion to set aside the default. I'm not telling you it will be set aside, but if you want to challenge this spousal support order, that's going to be your first step, is to do that.
Okay.
Okay.
So the divorce is final in July, sir. Is that correct?
Well, I
And
looked at, just give me a moment here, because I think it was in May when it was entered. The decree of dissolution was entered May 16th, 2022. There really wasn't anything entered in July. So that's
when he was supposed to start his payments.
okay. Well, then maybe I need to adjust this. So that would take 2 months off. That would be $400. So we'll go July to January of 2023.
And also, Your Honor, he's to pay the clerk, and then the clerk will send me the money.
I am not going to award the interest that you've requested. So I will leave it at $1,400 then. And then if there's a failure to pay for February and on, you could bring a subsequent contempt motion in the future.
So what do I need to do? Actually, what did you tell me I need to do, sir?
Okay, I'll just give me a moment.
He's self-employed. That's what it is. That's what I was trying to say.
I don't work at all.
How do you got a truck and 2 cars and everything else?
All right, don't talk to each other. That's not what we're here for. What I suggested, you may want to write this down, is bring a motion.
Hold on.
Bring a motion to set aside the default.
A motion to set aside the default.
Right.
Where did I
And
get those papers?
you have to, I can't tell you that. There's no form for that. You need to do a declaration explaining why you did not respond to the documents. And then the court will consider that. If you do that,
I
then
did that, sir.
I did not see that.
I did it on February 2nd. I have the paperwork right here in my hand, actually.
I see a declaration that was filed on February 2nd, but that there needs to be a specific motion set before the court to set aside the default. And if you want to rely on that declaration, you can, but there needs to be a motion set so that it's in front of the court and it gives Ms. Jones a chance to respond. Okay. I'm not allowed to practice law. I'm probably going beyond where I should at this point, But I want to tell you what needs to happen, and then I can't really tell you more beyond that.
Okay, so I don't want any trouble or anything or any problems or anything. So I have to pay this money before I file this or
No, you don't.
Okay, so if I go file this paper today or tomorrow or whatever, so when will you guys will hear it again and then tell me when I have to pay or whatever if I lose or whatever?
Well, you've got to get something that's called a notice of hearing and fill that out and pick a day when this gets heard. It will be a Thursday at 9 o'clock.
Okay.
And then you got to send that to Miss Jones so she has a chance to respond.
So the money that's been
Okay.
incurred from then till now, he still owes me, right? And then once the default gets set aside, then,
It may change, but
Okay.
I don't think it changes what's owed at this point.
okay.
All right. All right. That's all I can do for you right now. And if the motion comes up, we'll take it up at that time. Okay.
Okay, I have one more question for you, sir, if I may.
Briefly, please.
Yes, sir. So you're saying that the money that's owed, you said something like $1,400 or something like that.
That's correct.
So I don't have to pay that right away, or
Well, it's going to accrue interest at 12% starting today. It's up to you when you can pay it. And every
Okay.
month another $200 gets added. So
Okay.
you can decide how you want to address that. Okay.
okay. All
all right.
Thank you.
Thank you.
Your Honor, this is Lacey Harlan. I was curious if we could possibly do Harlan and Wade. I need to get to work if that was possible.
Okay. Let's go ahead and take that case, and then we'll go to Estrada after that.
Thank you.
All right. I think Ms. Fellows is here and Mr. Wade is here. Let me just pull that up on my computer. All right. Ms. Harlan was asked to do a hair follicle test, which she did, and Ms. Fellows filed that with the court. I noted it was positive for marijuana and also positive for whatever substance it is at the end of the list. I was interested in Ms. Fellows and your take on that test and how you view it, given the issues of the parties.
Yes, Your Honor. This is actually a 12-panel UA. It was requested because the hair follicle test that she did prior did not reflect the Suboxone that she had reported that she was on. So that's why that was ordered. So that is what is listed at the end, is basically the Suboxone.
Okay.
So in my mind, this is exactly what I figured it would show. So I have no concerns regarding that.
Okay. All right. How I changed the visitation situation a little bit last time we were together. How has that been working out? Let's start with Ms. Harlan.
It's been awesome. I really appreciate it very much.
Okay, I've got Mr. Wade shaking his head. So, Mr. Wade, what's your view of how it's been working out?
You had me set it up to where, and I think there was some confusion because she has him now more than me, but let's get started with the daycare situation. She was just supposed to, you had me set it up to where she can drop him off and pick him up Thursday and Friday. I talked to Beth, and my son had hand, foot, and mouth disease, and so he couldn't go there when she had him. So there's an issue with her son that, he's molested a cousin and all that stuff, and it's just a serious issue that needs to be addressed. And she got him more days, but she took my mom off of the pickup and drop off.
No, I have not. I can't touch any of that.
Let Mr. Wade finish.
Sorry.
And then outside of the place, she was screaming and cussing at my mom, telling her to go do drugs with your son, flipping her off, driving crazy out of there. really not a good thing to be doing at the daycare. And the daycare people were standing right there and watched it all. And she did try to take my mom off the pickup list.
No.
And this is at core.
Yes.
No,
And
I did.
also, before she had him Friday, Saturday, Sunday, and she dropped him off Monday morning with my mom. And so I had him the rest of the days. You gave her an extra day last time. And so now I have him 3 days and I work. So I get him just a couple hours. And I filed this so, you know, he was safe. She is not taking him to daycare Friday. She told my mom she was going to take the day off. She was at work. Beth recommended that maybe she have my mom watch him. And she had her friends watching him when CPS showed up her house. And JJ was there too.
JJ was at school.
Just a minute. We're not going to respond like this.
Sorry, Your Honor.
Mr. Wade will finish and then I'll let you respond.
Okay, maybe JJ wasn't there, but the CPS lady thought that he was. But other than that, you know, I would just like it to go back to the
Friday
previous,
through Monday morning.
Yes, that would be better, so she doesn't have any access to the daycare and she can't mess that up. This is something that I set up, and yeah, it's just been a mess since this has happened. And yesterday her friend and her were video recording me leaving Safeway. There's a protection order and she shouldn't be doing that.
Your Honor, may I speak? My friend saw him at Safeway yesterday. I was not with her at all. I ended up seeing him a little bit later because I was taking Caitlin to go I dropped her off to go pick up her friend at Silver Star because her friend had been drinking. And that was while I was on my lunch break. She was with a girl named Bree that works at Safeway. My friend Caitlin was, and was picking up Bree from work and taking her home. And so they did see him. But that was it. Nobody was recording him. And I have never not taken him to daycare, other than when I wasn't supposed to, because he had, so last Sunday, or yeah, well, whatever, the Sunday before, whatever, he woke up with the hand, foot, and mouth, or puked Sunday early morning. And then so the next Monday, I called Lori, his mom, and told her that he was sick. So we met at Safeway at Ocean Beach, and I dropped him off with her. And then they had him. And then Thursday, I picked him up from Lori. And I have not tried to take her off of anything. I would never do that. I don't even know where that's coming up from. All I have, he signed papers for me to be able to pick him up and drop him off, and that was it. And it's just, this is getting ridiculous. He called CPS saying that someone's living that my child JJ's son or dad, Jamie, that he's named after, was living at my house, selling drugs out of my house and things like that, and which is not true at all. I've had 3 CPS workers contact me, and it's just ridiculous. He came back dirty for drugs, admitted that he was doing fentanyl and meth. His own mother is in treatment now too because she was doing drugs as well. Or supposed to be. That's what Miss Fellows just told me, that she was going to be getting into treatment too. So I think that things should stay the way they are. He has a nice big home. He's with me. And everything has been great and fine. I pick him up Thursday from daycare. I drop him off Friday morning. And then I drop him off Monday morning. And nothing has been bad. I was 15 minutes late one morning to drop him off to daycare. And the only reason that is because kids take a little longer, to get out. He didn't want to go to daycare. Now he's been happy every time that he goes in. And there's actually been a few days when Cody has not went to work and to drop him off just to Lori and stuff at the daycare, or Cody didn't go to work, so he didn't go to daycare, and I had to pick him up from her outside of the daycare. And it is court ordered that he goes to daycare, and he was not sick at that time or anything like that. Beth Fellows told me that it is court ordered for him to be at daycare, and that whether it be me or you, we are not supposed to take time off. We are not supposed to do anything to be able to do that. So
Does he go to daycare on Fridays?
Yes, he goes to daycare on Fridays. I work. I have $2,000 in bills. I pay $1,600 a month for rent, and I pay water, sewer, garbage, everything like that too, and my cell phone. I have to work. Like, you know, I have bills to pay.
All right,
my son goes to school, everything, you know, it's like everything's been fine. He's just trying to, I feel like he's mad. Sorry.
Just a minute. I want to hear from Ms. Fellows.
Yes, Your Honor. As you can tell, there's a lot of adversary issues between these parties. It's really hard at this point to figure out what's up and what's down. So I do know that the father has called CPS. There were 3 CPS workers that went out to the house, to the mother's house. I did make contact with the one that actually saw Cashton, the little one, in his matter.
Let me stop. I'm getting some feedback from Ms. Harlan. I'm going to mute you for the moment, and then you'll need to unmute yourself when you speak again. All right, thank you. Go ahead, Ms.
So I did talk to that CPS worker yesterday late afternoon, and she said that there were no concerns in the home. The home was clean. There was definitely a good bond and relationship between mother and son, Cashton. She saw JJ, the older son, as well. There was a little bit of concern regarding JJ, mainly because he's very, very angry, and he has issues because he was actually taken out of the mom's home. This is past history, but he just has a lot of fears of CPS coming into the home because of him being taken out of the mom's home when he was much younger. So that in and of itself makes it's understandable. But in essence, the CPS worker, Heather, didn't have any concerns about the mom's home, cleanliness, the bond. She said that Cashton was happy, healthy, no marks on him, no bruises on him, no blisters or anything else, because she knew about the hand, foot, mouth. She's been around it before, so she knows what it looks like. Said that there were no marks on him or anything else, so there wasn't any of those concerns. I am concerned about the issues between the parties and this back and forth stuff. I did try to I did let them know is that the court did order that the Cashton is to be in daycare. They're not to be taking time off to be able to spend time with him outside of the time that they're already ordered to have. It's important that Cashton have that interaction in daycare, and it just kind of sets up parameters and a routine for him and for these parents. At this time, you did make the changes to add time to mom. I had not recommended that, but the court felt that that was the direction they wanted to go. Because there's so much going on, I have no recommendations to make at this time other than to maintain status quo. And just the hope is that these parties will kind of let things quiet down and start this routine and things like that, so then I can work on my investigation. There's just so much back and forth stuff going on that it makes it extremely chaotic to try to figure out what's going on. They're keeping in contact with me, the parents are, but they're just pointing fingers and just this, that, and the other thing. And it makes me worried about any future interactions between these parents, but I will hope that things will quiet down a little bit. And regarding the grandmother, Cody's mother, the paternal grandmother, I am aware that she has engaged in some kind of support services through Core Health. I am not certain about whether or not she's in actual treatment So just wanted to clarify that she is just getting some support services through Cora Health because she is an important part of the father's support system as well as Cashton's support system. So that's the information I have regarding that.
First of all, I think having the pickup and drop off at Core from daycare is something that is working. I'd like to continue. Second of all, I wanted to give Ms. Harlan more time with the child, but I'm not sure I wanted to move it to a position where she had clearly a lot of more time than the father. And that, I think that's what I did. And I think I need to make a shift on that. Okay. So,
Your Honor, please, I mean, he just came back dirty for fentanyl and meth. I mean, and his mom uses. It's just that I don't feel like that's fair. When I'm clean, I'm doing everything I'm supposed to. Like, I feel like I'm getting punished for him doing what's wrong.
you're not being punished. I'm trying.
I am though. Now now I'm losing time that I'm,
all weekend long. You don't work on the weekends, Lacey.
Miss
Why can't-
Harlan, your combative nature today
I'm sorry.
is
I'm
causing me a lot of concern.
I'm just upset.
And that is causing the guardian ad litem concern, and it's not going to serve you well in this proceeding. All right?
I'm sorry. He just keeps pointing fingers at me and just keeps trying to do and all I want to do is get along. I don't want to have to fight like this. I don't want things to be, I just want us to be able to be parents. That's all I want. Like, honestly, Your Honor, really, that's all I want.
Then you'll understand why I want to make things more equal. Okay? That's what I'm about to do. All right. So, where things are at now is Ms. Harlan has the child from Thursday after daycare until Monday morning. I'm going to change that so the first, third, and fifth weekends, if there's a fifth weekend, and that's based on Fridays, she'll have the child from Friday to Monday. And on the second and fourth weekend, she'll have the child from Thursday to Monday. So I'm building another day, 3 more days a month in for the father, which I think is going to equalize things a little bit better.
So then every other Thursday, he'll have him. Is that what that is?
If it goes every other week, then every other week you have Thursday to Monday. Every other week, you have Friday to Monday.
If you're going to do that, my days off for the weekends also. And so I'm only having him during the week. And that's when I work. So can I maybe get him on a weekend too?
That, I understand that's a concern that you don't have any weekends.
None.
And
I haven't since this whole
Can I say something? If you look at his parenting plan, when he put it in, he asked for me to have weekends. That's what he asked for in the very beginning.
That was for the safety of my son. And now that they switched it around.
And that's when my son is there even more that you're worried about. So I'm sorry.
Again, this combative nature by both of you really isn't going to help us. I'm going to keep the schedule as it is. I want Mr. Wade to know, I recognize he's not getting any weekends, and that's going to have to be rectified at some point. I want Ms. Fellows to finish her work in making recommendations, and then we may switch this whole visitation issue around in order to provide weekends to Mr. Wade. Ms. Fellows, how long do you think it'll take you to wrap up your work in this case?
Well, I would say 60 days, to be honest with you, because it's really just so important for me to get a feel for this working. And I haven't been able to peel back some of the layers, the concerns that dad has about mom. I haven't been able to peel back some of the layers about what mom has concerned about dad and things like that, just because there's been so much of this back and forth stuff. And I have requested CPS records. So they're out, and I did that when I first got the case. And so they're out. I'm not sure, but I did get information that they would be getting back to me, but I don't think it's until maybe March.
Okay.
I had asked for them too at the beginning, and they said something about 90 days, so it should be around like March or April, something like that too. So
I'm going to try to push this a little bit. I'd like to set the next review hearing for March 30th. Ms. Harlan, I want you to expect that if I redo the parenting plan at that point, I'm going to give some weekends to Mr. Wade. So I just want you to understand that starting right now. Okay. Okay.
yes, and like I said, I'm so sorry. I'm not trying to be combative, and I'm not trying to, argue. It's just, this is my life.
What would be really helpful for the next few weeks is if both of you could be cooperative with Ms. Fellows in order to get her the information she needs. Okay?
I've been asking her to come see my house and to talk to, that's what I want, so.
All right, so I'll make that change in the parenting plan. There should be a copy of it available by tomorrow if you want to see what the order is.
Does it change today? Because today's Thursday and normally I'd get him today. So does that change today or?
Let's start next week, whatever week that is. So we'll have you go ahead and pick them up today.
Okay.
Next week we'll go to the plan that I'm putting together.
Okay. Thank you.
All right.
Is there any way I can ask for like a mediator to, talk between us so, it's not just my mom? Like I have someone willing to do it besides my mom.
We barely even talk. Like, honestly, we just talk like if we're
getting. Our son's been sick. Our son has been sick every time he's came back from there. And they're sick. So we have to figure this stuff out. And my mom is not really enjoying doing it. Lacey is cussing her out at daycare and making a shit show. And it's not okay.
She told me to be a mom and stuff. She was talking crap to me. I did tell her to go do drug, but Your Honor, I did not do anything to get his mom off of anything like that. Me and his mom have gotten along amazing. Like me and her were closer than him and her. Like honestly, so
let's. If there are issues like that, I encourage you to direct those to Ms. Fellows and let us know about them. Okay.
Okay. Thank you. I'm sorry.
All right. Thank you, Estrada. And
have a nice day.
Miranda.
Yes.
And I see Mr. Estrada and Miss Miranda. Good?
Yes.
Thank you. Let me just look at my notes here. I don't see Miss Height, who was is the guardian.
No, I didn't. I haven't seen her either throughout this duration.
Okay.
Oops.
In reviewing the file, a question, Ms. Miranda, you were to do a DV evaluation.
Yes. So I have a couple questions as well. So I'll just kind of let you respond to this first. So I am actually in contact. I got off that hearing the last time I spoke with you. I was in the waiting room, not able to get in, called and they patched me in. So I was unfortunately not able to hear kind of feedback from Mr. Estrada or Miss Height about that previous declaration. I know I had a conversation with you about the DV evaluation. So right now I am in contact. It's called Healthy Decisions. It's based out of Camas, Washington. They do everything over the phone. So it is a $400 or $450 fee out of pocket, which I'm working with them to pay because obviously, I work through the school district. I don't make a ton of money. But we are working together to make payments and working in good faith with them so this can be established. And she did tell me that it's going to be quite a lengthy process. She has not decided, like, we're not even at the point if she wants me to do extended treatment or not. I'm still at the introductory level of just being evaluated. I do have a phone number. Like I said, it's all via phone. They don't do anything in person. So I have a text communication phone number that they are working with me on, and a direct line for their actual counseling service. So, excuse me, I speak with either Susan or Maria. Neither have provided last name. I'm sure it's for anonymity or for some reason like that. It was quite actually difficult to find someone who does one of these nearby. I probably contacted about 10 mental health agencies and got pushed all around. There's one other person I knew of in town, but there's a conflict of interest. So she was able to get me finally in contact over the last week with Healthy Decisions and patch me through to them so that I could be in compliance. So as far as that evaluation goes, she did say that something would be submitted to the court to show compliance. And again, I do have their contact information as well.
So thanks for your efforts on doing that.
If I may say something, Your Honor, I think a lot of it boils down to finances more or less than my, commitment and willingness to comply with the requests, which is unfortunate because I know that draws things out. Another concern of mine too is, we've been in this situation, we've been separated now for over a year, been in quite a bit of months, in hearings, which on one side, I do appreciate the thoroughness of it because I think it should be fair for both of us. I think that we're both making a genuinely good effort for the kids. But then also, like, if this would have been established much longer ago, I think it could have been taken care of. And my question is, why would this be established now? Because Miss Height has had the information of the domestic issues between Mr. Estrada and myself this entire time. So it's just one of those things that as far as custody of my kids, that's drawing that out now, that distance between them. And then also with you and I discussed this still being a temporary order. I'm really curious to why there was such a drastic change in the custody arrangement due to this. Again, we have been in a temporary custody order, 50-50 custody, going back and forth. I can only speak for myself, but as far as I can see, nothing has regressed between either party. If anything, we are both moving on and establishing ourselves separately. So it's just kind of odd that, we went almost a year once our initial temporary plan was assessed and put forth doing 50-50. And then there's, I'm needing to do this, which is still fine. I'm not trying to argue with that, but why such a drastic cut back on the custody when there's nothing that's happened, recently to cause that? I mean, going from 50-50 custody to now me seeing my son every 2 weeks on scheduled time, that's pretty extreme, even in the children's interest. Because I haven't done anything to, in this time frame to warrant it. I've complied with everything. I've complied with Mr. Estrada's restraining order. There's been nothing derogatory happening in my life separately. I've maintained a stable home. I have a job. All these things I've provided similarly to, what he does as well. And I'm really curious as to why the cutback on, visitation and custodies, like I said, so drastically.
Well, it seems it's related to domestic violence issues. And I think the recommendation by the guardian ad litem was what is going on now, which is Friday from after school to Sunday at 6, first and third weeks of the month. And then the indication was after the domestic violence evaluation, depending on what it says, that the court would consider adding a 5th weekend. So that that's what's before us on that report. I think that's what's driving what's going on now.
Yeah, which is
Here,
understandable, but it's kind of odd that that wouldn't have been established from the very beginning. Oops, sorry if okay, I'm still there. Because there's all this time, that we've been 50-50 and there's been no altercations and nothing has happened and the kids have been fine. And if that was, if that was like her initial concern, that could have all been established instead of changing it, completely now.
let me hear from Mr. Estrada and how he
Okay.
thinks things are going. Mr. Estrada?
Yes, Your Honor. Everything is in the GAL report as to why the recommendations were what they were. My initial intent when I filed my initial petition was for me to have custody of Sebastian, with her having, alternating weekends. So.
Okay.
And I understand that, but then if that was what was requested and what was recommended, should that not have just been established then, instead of getting the kids comfortable in a routine and then so drastically changing it almost a year later, pending something like this when there's been no issues as far as the children go, and not even with Mr. Estrada for that matter, since we've been separated?
Well, the guardian ad litem needed time to investigate the matter fully, which she did, and that took time. There was issues with payment to the guardian ad litem on the other party's side, which also extended this out and her getting her report in. We still haven't gotten a hair follicle test. So there's a lot of concerns on my end.
That was recommended in her report. It was never put forth to me in court as a compliance concern. I have no problem doing that. But again, it's just another financial commitment that I have to make. And it's all these things and hurdles. It's like every single turn we go at, it's like another hurdle for me, but there's nothing set forth for Mr. Estrada, who has been party to so many of the same issues that I've had. Again, I'm more than happy to do all these things, but again, there is a financial concern because, I don't have the same financial advantages as Mr. Estrada, and I think that has worked very well in his favor. So again, it's not an unwillingness to do it. I'm more than happy to. But also these are things that she suggested, but the court has not told me you specifically need to do these things to be in compliance. And Miss Hyde has had these reports and information this entire duration, whether she had her money or not. And she also didn't investigate much on my side, on my behalf. She submitted her report within a week of talking to one person that was a witness for me.
Right,
and that was several weeks actually after she received my payment.
So let me go back. On January 5th of this year, Commissioner Cotterell accepted, it says the recommendations in the GAL report filed December 20th, 2022 are adopted in full. And then a review was set for January 19th.
Which is when it was adopted as a temporary until I do this evaluation.
So then we came back on the 19th and you showed up late. You and I had a discussion afterward. I indicated I needed to see the domestic violence evaluation. Apparently you gone to that, but I haven't seen what the evaluation.
Yeah, I'm still in the process of it. They haven't even finished it.
Okay. So when that gets filed, then I think based on the GAL report, we can consider the fifth weekend. But what's probably going to have to happen, and the reason I said it was temporary, is eventually we may get back to something that's more equal.
Right.
But, let's say the domestic violence evaluation says you need to go through some treatment.
Right.
I'm going to want that to occur before I make any additional changes
in
the parenting plan. So that's kind of where we're at. I'm not going to change Commissioner Cotterell's decision based on the GAL report. What I guess the next thing I'd like to see would be a domestic violence evaluation. Do you know when that might be available?
I can actually, if you don't mind, not to be distracted, like I said, it's all via phone. I can try to send her a text and ask her in our conversation where we're doing it if there's at least a reasonable time frame that she thinks.
Well, I'm not sure I have time for a back and forth right now. Why don't we set this out a month? That would be, I think, March 9th.
Okay.
Commissioner Nelson, permission to address the court?
Yeah, please go ahead.
When Commissioner Cotterill adapted the GAL report, he adapted it in full. The GAL report clearly states that a hair follicle test will be required within 14 days of court before any changes are made. So I would request that that would be done. And I'm more than willing to get it. If she wants to petition the court for me to have a hair follicle test, I'm more than willing to do it and pay for it myself. No problem.
All right. I will tell you, though, if it was prior to any change, which is somewhat typical, I'm not making any changes right now. So, I mean, I can request that, but, or we could wait until or Commissioner Cotterill decide that there'll be a change in the visitation plan. What?
Yeah,
so
let
Mr. Estrada.
Sorry.
Go first. Go ahead, Mr. Estrada.
Yeah, that's perfectly fine. I don't want to change anything from the GAL report and that it was adopted by Commissioner Cotterill. I just want to make sure that it was clearly stated in court today, just so that way there's no confusion that the hair follicle will need to be done.
Right. So let's say you get the domestic violence evaluation and we're considering adding that 5th weekend. I probably would order a hair follicle at that time.
So
Perfect.
if I just do it prior to that, to just have it all done, could that be considered when we reconvene as well? Or do I have to wait until
if
it's
the
ordered?
domestic violence evaluation has been filed, I'm sure you can just go ahead and do that. And then
Okay.
you would give that result to the clerk's office so they can file it in the court documents.
Okay.
And also give a copy to Mr. Estrada.
So what the GAL report actually stated, because of the duration of a hair follicle test and what it will show on it, is that I cannot provide the test any further than 14 days before court because they want it to show it within enough duration, whether I have drank or not. But I'm more than happy to prove a point, to be honest, because, by personal opinion, Mr. Estrada and his family seem to be so convinced I'm still drinking. I would love to prove a point. So that's completely fine.
Okay. I'm just saying that, let's say you did it tomorrow.
Right.
I would still probably order it prior to changing the parent.
Right, because it needs to be no further than 14 days prior to the hearing to establish it.
Right.
As valid. That's fine.
Okay.
I mean, it could be 14 hours, it could be 14 days. It's going to be the same. So.
Okay. All right. I just don't, I don't want you to unnecessarily have to pay for a
right
test. Okay.
One more concern I had, and I shared this in my previous declaration, and also this is in the paperwork, is my daughter, Kaya. Robert has no legal rights to for parentage. And she has been with him a majority, same schedule as Sebastian. Like I said, that's not a moral obligation because she has expressed personally she would like to be with her brother. I think it's already a hard enough time for them, but it is developing a concern. I can tell just, she's my daughter. She's becoming a teenager. I can see certain behaviors, and I'm not saying it's a result of that home. I'm just saying I'm a mother, and at the age my daughter is. So I don't know how to go about and establish that because I don't want it to be like a negative situation or an altercation because it's not me trying to be petty or nasty. It's just, I'm not going to willingly give up custody of my children. That's why I'm here doing what I need to do to have them. And I am the sole custodial parent for Kaya. And she is still, I'm only seeing her every 2 weeks. So, and they're also, you know, making decisions on their own. Like she told me last night on the phone about switching softball teams and things like that. And that's something that I need to be respected. And it needs to be discussed with me prior to discussing it with my child.
How old is she?
She is 12 years old.
Well, as you indicated, apparently Mr. Estrada is not the father.
He's not the legal, does not have legal parentage.
Okay, but she's been staying over there just to be with.
And she wants to be with
the
him,
child.
of course. I'm not denying that they have a relationship and that's her dad. I'm just saying I need to be much more involved. I need to be much more communicative with before big decisions are made in her life.
All right. You've stated that here. I don't know how I can better communicate that to Mr. Estrada. And I think that's something you'll have to work out between the three of you.
Okay.
Okay. Ms. Powers, are you involved in this case?
We are involved in this case, Your Honor, and I was just, as a friend of the court, going to let the court know there is a separate cause number involving the child, Kaya. She's not involved in this particular action.
Okay, thank you.
Is that, may I ask Ms. Powers, is that something that's new? Because I have not been given any paperwork.
Our office went through a whole process vacating court orders in this action because Kaya has a separate legal father.
No, no, I understand those. I understand what you're saying with that. I completely do. I thought you meant that there's going to be a new case with her, like something else presented. No, I'm completely understanding of that. And that's what I'm like trying to address is that legal parentage. Like having, you know, her have interviews privately with Miss Height and things like that. Like that's just not okay.
All right, let's
Your Honor, can I address the
confirm
court?
where we're at here. Go ahead, just briefly.
It'll be brief. Yeah, she never had any separate interviews with Miss Height. Miss Height said hello to her in passing when she was interviewing Sebastian. Miss Height has documented that, and it's came up in the past, and it's been in the report as well since she's been vacated from the orders. I let Commissioner Cotterill know in the very beginning that although I am Kaya's biological father, I did not establish parentage in the first 4 years of her life. And in Washington State, I had 4 years to do so, and I've been advised from many lawyers that, you know, that it's past that statute. So the state stepped in as the other party, Miss Miranda, added Kaya to this docket in the beginning, which legally she couldn't be added to it. That's why I've remained focused on Sebastian the entire time. The state stepped in and had her vacated because Commissioner Cotterill did order me to get a DNA test, as I already knew she was biologically my child, which I did do. But, you know, Kaya can't be a part of this. Whatever her legal parents want to do, they can do. She has asked to stay with me. She wants to be with me, but it's neither here nor there on this case.
Okay, that is true. That is true.
I only brought her up because Miss Height put her in the GAL report.
Okay, well,
That's
that would not be unusual because that's somebody who interacts with
right.
Sebastian. All right, so we're going to come back on March 9th. I hope by that time a DV evaluation will be filed with the court. And if you want to do a hair follicle test within 14 days of March 9th,
just to have it ready and be within that window.
We'll consider that. And everything else, the current visitation will remain the same. Okay.
Okay. So I just want to double check a date here to run it by you. So that'll be a Tuesday, March 9th, not a Thursday.
Is that?
It looks like that's a Tuesday.
Well,
I just want to confirm because they've been generally Wednesdays or Thursdays.
March 9th is a Thursday.
Oh, okay. You're right. I'm so sorry. I was looking for some reason. I'm on a separate year. Okay. So March 9th is a Thursday and 2 weeks before that. I'm just going to have it all submitted for you so that hopefully we can establish things further and not keep carrying on.
Okay.
Okay.
All right. I think that's it on this case. And we'll see you a month from now. Okay.
All right. Thank you. Have a good day. Bye.
Thank you. All right. I'm going to end the meeting.